He lives in the marital residence. He has more discretionary income. He has more regular monthly income, and he has the ability to cut some of his bills back, including internet, cable, things of that nature. My client needs to be able to survive.
The house payment is $2,500. And that is a large house payment for these parties, but somebody's got to pay it. He's got to make these payments. He makes the house payment, the car payment. He pays the Amazon Chase credit card of $125.
There is a motion to modify the temporary order in this case and a motion to appraise marital property. Ms. Locke, it's your motion. What is the status of these motions?
Yes, Your Honor, we have not been able to reach a resolution, so we would like to be heard on both motions today.
All right. How can there be an objection to appraising marital property?
Okay. I think that we have resolved that, Ms. Locke. I think we will agree to use marital assets, and then we'll split them equally between the parties to pay for it. And that was the only issue. And the 10 acres to the son. We want to make sure the 10 acres to the son, we understand the parties have agreed, and they are not be included in the appraisal. So if we have an agreement on those terms, this is not an issue.
Yes, there's an agreement.
Okay. Okay, so who's going to submit the order? Because there's additional conditions, so I want an order on it.
I will do that.
Okay.
In today's tense custody battle, the court dives straight into Fitzgerald versus Fitzgerald. The father represents himself, while the mother is backed by an attorney. From the start, her lawyer insists the father's claims are either outdated or flat out false. She presents evidence: a 911 call where he himself admitted it was a seizure, hospital reports showing zero alcohol, and even text messages that disprove his story. The defense pushes for temporary supervised custody with the mother's parents overseeing every visit. But when the father responds, things get heated. He argues this wasn't just a seizure, it was another alcohol-related episode, citing a blood test with a shocking 0.2 alcohol level. The judge immediately cuts him off, reminding him he's no medical expert and that secondhand claims won't be allowed. The tension rises as the father tries to defend his position under strict questioning.
Can 10 acres do you any good in Butler County? You got to have 40 acres to build anything unless you get an exemption from the county commission. Unless it's not in Butler County.
And registered with the deeds.
Okay. I understand it's already been surveyed and registered with the deeds, so we have already taken action on the 10 acres.
Okay. Okay. Your client is the plaintiff, Ms. Locke.
Yes, Your Honor, the petition. Correct.
She filed the order. And she filed the temporary. But she wants to modify it. All right. You may proceed.
Your Honor, when this case was first filed, we believed that the parties were in agreement about most of how the case would transpire. And we find ourselves months down the road without reaching much of any resolutions. When my client first filed, she agreed to vacate the marital residence and live temporarily with family friends in Topeka. Her situation has changed due to the length that the case has been pending, and she had to seek alternative housing options closer and in Wichita. That has necessitated her needing spousal maintenance. Prior to the separation, the parties agreed to split their excess income monthly equally, which resulted in them each having about $800 in discretionary income after things were paid at the household. When she filed for separation, that $800 continued to come to her. However, there's a huge disparity in monthly income, and now that we haven't reached resolutions, she needs some additional monthly income in order to be able to survive. Miss Sawyer gets about $1,000 a month from Social Security. Mr. Sawyer gets about $6,800 a month in monthly income between his pensions and then his Social Security payments. He has been responsible for several of the bills. The largest bill that he is responsible for in the temporary order, other than the mortgage on the marital residence, is my client's car payment. And I will give the court a little bit of history on that. The parties sold off some pretty significant acreage not long ago after she purchased her car. At closing, Mr. Sawyer elected to pay off his truck and some other equipment that's at the marital home and opted to keep her car loan because it had a low interest rate. At that point, he agreed to continue to pay her monthly car payment and has continued to pay her monthly car payment despite there being funds at closing to pay off her car in full. So at this point, he pays her monthly car payment, and then they divide that extra $1,600 a month, giving her a total monthly income of about $1,800 to his $6,000. So what we're asking the court to do today is to make that a little bit more equitable. Essentially, we're asking the court to give her approximately one half of his one of his pensions monthly, which we believe will be close to what the final outcome is in this case. So we're asking the court to award her formally $1,800 a month in spousal maintenance, which is in our motion. We believe this is supported by the factors. Both parties are retired. He lives in the marital residence. He has more discretionary income. He has more regular monthly income, and he has the ability to cut some of his bills back, including internet, cable, things of that nature. My client needs to be able to survive in a new rental in Wichita until this case is resolved. She has no access to any additional income. All of those items are held by the respondent in this case. So we're asking the court to award her formally $1,800 a month in spousal maintenance.
But the courtroom drama doesn't end there. Next up is Riley versus Riley, a battle not over children, but over a mortgage. The ex-husband, still tied to the house through the loan, demands his name be removed so he can move on with his life. His lawyer explains that the divorce gave his ex-wife the house, but left him financially shackled to it for years. Then comes her turn. She insists she's been working on refinancing and just yesterday got approved with a cosigner. She shows emails from the bank, but the husband's attorney isn't satisfied. The judge steps in, setting a firm deadline. She has 60 days to refinance or risk paying attorney's fees. It's a sharp warning and a final chance. With paperwork ordered and deadlines in place, the judge adjourns the case, leaving both ex-spouses facing a ticking financial clock.
All right, 1982. That makes this about a 43-year marriage.
Yes, Your Honor.
As of yesterday. Mr. Morgan, your client hasn't filed a domestic relations affidavit that I can see.
Yes, we have, Your Honor. I will show you. Can I share screen?
Sure. What, can you give me the date so I can try to find it?
Oh, I think it was either last week or the week before that.
Okay, well, it's not in the court file. Okay, here we go. I got the response.
Okay. In the first paragraph, I point out that here's what he's paying for the petitioner. Car insurance, $50, car payment, $435, cell phone, $85, okay? And he has paid her $800 a month. This is a total of $1,370 per month, all right? Now, we're asking the court to just keep it the same because we believe that this makes everything, the net incomes of the parties equal, and we believe that that's the fair way to do it. Okay, we go on to our next paragraph, number 2. We did send an email to counsel. We were a little late on the DRA, but 2 months ago we outlined this, and we said, here's his income, $680. He pays bills. This leaves $260. We pay her $800. He keeps $800. and their net incomes are the same. And that's what we've been doing, and that's what we believe the court should continue doing. All right, paragraph 3, the DRA we submitted for Mr. Sawyer supports those statements. He does not have the financial ability to pay any more. And if the court does increase the spousal maintenance above what this is now, we request the court to shift her expenses back to her. And that would be the cell phone, the car insurance, and the car payment. Now, that just involves a lot of work and shifting. We don't think it's necessary. That's why we believe we should continue as is.
Okay.
All right, now let's go to his DRA.
Okay. Well, my impression is that she will, if she got the 1,800, she would do the 85 cell phone and car insurance, but the car payment is in dispute because he just took that on as his debt when at least, I mean, if his truck was paid off, he could have paid off half her car and half his car and reduced what was owed for both of them for purposes of moving forward. But if he took the money and just paid off his truck and chose not to pay off her vehicle,
yes, but we're getting down to, go ahead.
Well, I think she understood that to be the agreement. He was going to keep making her car payment for her.
Well, regardless whose debt it is, he has to pay it, and that reduces his net income. And that's what our DRA shows.
Okay, let's go through that.
Let's go through his DRA.
Why? We borrowed money against my truck. My truck was already paid off. We borrowed against it. Her car, we borrowed against it. We paid off the truck. We borrowed against her. Right.
The judge then narrows the focus. Should the mother be allowed supervised visits every weekend? The father reluctantly agrees, but only if it doesn't interfere with his daughter's Girl Scout meetings, birthday parties, and school activities. He argues her social calendar shouldn't be disrupted. The mother's attorney fires back, saying the visits are temporary, safe, and always supervised by the grandparents. The courtroom grows quiet as the judge weighs both sides. Finally, the ruling comes down. The father will maintain joint legal custody, but the mother will get supervised parenting time every single weekend. The case is referred for a full investigation, and both parents are ordered to split the costs. The gavel falls, Fitzgerald versus Fitzgerald is adjourned.
All right. Let's go to page number 1, paragraph 9. It shows incomes. It shows his income. We've attached a statement thoroughly analyzing it and going through all the net. His income is basically $6,800. Her income, we believe, is $1,038. If you go below that, and then we go down to paragraph 11, this outlines his living expenses. All right. Now, if you go back to my email, these all correlate exactly. And if anything, if you go through his expenses are a little bit light. Of course, the cell phone includes her expense, and the car insurance includes her expense. You go through that. We spend a lot of time on all these. And what's significant is he puts all of his expenses on a credit card. And we listed the credit card, but we didn't put the payment in because that would be a double dip. He puts everything on his credit card, and we have submitted those documents to the opposition to show his spending.
Okay,
right.
Well, that's great. That really shows what he's doing with his money. Why is his, are they all electric? Why is his electric bill $400?
It just is. It's a pretty big house, and it's not that efficient, apparently.
Yeah.
What?
It's a big house, and it's not that efficient, but, the records show that that's what he's spending. Now, another thing the court should take note of is when we go to paragraph 12 on our DRA, the house payment is $2,500. And that is a large house payment for these parties, but somebody's got to pay it. So,
Well, not really. I mean, right now, yeah. But somebody doesn't have to keep it. They can both downsize, sell the house, and find something else. But
oh no, we agree with Your Honor on that, and
okay.
that could be a way to resolve this. But for
Okay.
right now, he's got to make these payments. He makes the house payment, the car payment, you know, when you look at this, it really doesn't matter. Well, is it her car, his car? It doesn't make any difference. He's got to make the payment. All right. If you go down, he has a credit card of $40. He pays the Amazon Chase credit card of $125. He believes he is now with Amazon and both parties contribute to it. He is paying that credit card every month. So she does get a benefit there. If you total all these up, if you look at his income, his net, all of his expenses, his net balance is $632. If he pays her $800, he's $168 in the hole. So that's why we believe this is fair. He pays her $800. He pays those 3 expenses. He gives her, and when he does that, she has a net amount which is basically the same as his. All right, now let's go to her DRA. And that would be our Exhibit E.
All right, hang on a minute. What makes him think that he needs $500 a month for hobbies and entertainment?
Because that, you know, it's kind of hard to describe, but that is anything that he does. That's anything and everything he does outside of that house.
Okay.
He does play a little golf. He does do things with his family. He might go do this or do that. And that means he only spends $125 a week on activities. And that includes everything he does. So if you look at it that way, that's really a pretty low amount. To restrict that down means a person basically couldn't do anything outside of their house other than hike and walk at no expense.
Okay.
And we're still not told.
Just if you did a quadro on the Teamsters, she's looking at getting $1,348 a month.
I just think that that's something we can look at in the final resolution. But right now,
I think the parties ought to start getting into a posture, absent the house, where they know what they're each going to be working with monthly.
well, that's a good suggestion. And we can work toward that. But right now, if he gets hit with that much and has to pay all these expenses, he will not be able to do it. He simply will not be able to do it. All right, let's go through her.
How old is your client?
75.
75.
Oh, wow. Okay. Ms. Locke, how old is your client?
She is 70, Your Honor.
Well, they both look good and they both look healthy. All right, go ahead, Mr. Morgan.
Okay, if we look at the petitioner's DRA, rent is $1,000. We don't know, we have no documentation for that amount. Okay, I'm gonna let the court find it there. It's our Exhibit E.
Okay. Hey, by the way, what's the interest rate at through Members Mortgage, White Eagle Credit Union?
2.5%.
Okay, well, you can't do any better than that.
No.
All right, let me
Yeah.
get to E.
And Your Honor, you had a question earlier, and I just have a clarifying point on it before Mr. Morgan continues. It is a house and 120 acres that's covered by the mortgage payment. Is
Right.
my client?
Well, I was trying to figure out if they sold off some, was that separate? Was that some other property?
There was sufficient equity on the house and 120 acres for them to be able to sell a portion of it.
Okay. So the mortgage company released it and gave them permission to sell it.
Yes.
Yes.
And have they released it and gave them permission to deed 10 acres, give 10 acres to their son?
Yes.
Yes.
Okay.
Because we're imagining
Not
there'll be
careful
some
with
significant.
acreage, you reduce the value of your overall residence by having some weird acreage amount.
Yeah.
Usually
we
it's
haven't looked into
parcels.
that, but we will, and that will be part of the appraisal that we're going to do, is to have somebody assess this land and the house and give them possibly some pointers on what to do and how to do it.
Well, I'm not trying to be mean, but I don't know that I have to approve them gifting 10 acres to their son if neither one of them have enough money to live on.
Well, that
Why
is the
am I not
court's.
finding E? E is the petitioner's
It's
revised
the
amendment.
revised
I have
ERA.
that right here, so I'll just look at it in here. I would be interested in seeing his credit card statements that are a good reflection of what he's doing monthly, but if you don't mind, but I'm looking at the revised domestic relations affidavit right now.
Okay, if you go to paragraph 12,
Okay.
the rent, we don't have any kind of document to support that, but it's not terribly high. But what we do question is line number 4 for health insurance. She's on Medicare. They're both on the same Medicare plans. They should have no out-of-pocket expense for health care at all. That would take $224 off of her DRA. Okay.
Well, you gotta pay for supplemental,
Well,
and usually out of your Social Security comes your Medicare Part B.
okay. And Your
It
Honor,
reduces your Social Security,
and,
so you do pay. I mean, my husband pays $500 a month to have Medicare.
okay, and if we in our exhibits we have her Social Security statement, and what it is the amount of income has already
Okay,
taken.
let me look at her Social Security statement. I'm sorry.
It's Exhibit I.
Okay.
And Your Honor, just for the record, we received these exhibits yesterday afternoon, and so I did not have the opportunity to discuss them with my client in advance of the hearing.
Okay. Well, I may end up having to take this under advisement anyway, because I'll be frank, I have cases set every 30 minutes today.
Well, do you have time
Can you
next?
give me the bait stamp number? That'd be a whole lot faster for me. There's bait stamp 34.
34.
All right.
We
I'm
could do
looking
this
at
next week, Your Honor, if you have time.
I don't know if I do or not. If I have a
Okay.
jury trial, no. If I don't have a jury trial, I may. But I won't know that till Friday.
But what it is
Go ahead.
we're using their nets, and if you see over to the left, it says Medicare Part B taken out. We've allowed that to be taken out.